Good evening, everyone, and welcome to this informational webinar on Nantucket's annual town meeting, short-term rental warrant articles 59 and 60. My name is Kathy Baird, and I'm a co-founder and the president of Nantucket Together. For some quick background, I began visiting the island with my family and friends in 1985 and bought my home in 1993. I have served as a member of the board of the Tom Never Civic Association since 2005 and was recently reappointed by the town manager to my third three-year term on the advisory committee of non-voting taxpayers. I also served as the Nantucket Together representative on the STR working group. The purpose of this session is to learn about the Land Court's judge's recent short-term rental ruling and clear up confusion about the short-term rental warrant articles through a better understanding of the ramifications of each. We are recording the session so others who could not participate in the live webinar may view it later. Tonight, our guests and panelists are attorneys Stephen Cohen, who sponsored Articles 59 and 60, and a well-known local attorney, Arthur Reed. Steve Cohen is a partner at the Nantucket law firm Cohen & Cohen Law. Arthur is a partner in the Nantucket law firm of Reed, Gullickson, Hanley, and Gifford, whose practice has concentrated in Nantucket real estate and land use matters since 1973. They have both appeared before our local zoning board on behalf of their clients on permitting and land use issues and are thoroughly familiar with the Nantucket's unique zoning bylaws. Once the panelists have finished their short presentation, you will have the opportunity to have your questions addressed. We will alternate between those submitted in advance and those posted during the webinar. You may ask your questions by typing them into the Q&A feature of the Zoom dashboard. Because we only have 1 hour for our session tonight, we will not be using the raise hand Zoom feature so that we can get to as many questions as possible. I will do my best to eliminate duplicate questions and use the questions we received in advance, as well as those posted live in the Q&A feature. You may post your questions specifically to one of the panelists or leave them open to either person to respond. We will be capturing the Q&A contents so that the questions and responses can also be posted on the STR webinar and FAQ page on our website. Welcome, Stephen and Arthur. Arthur, could you begin by providing some background on the recent land court ruling and what it means for current and future STR homeowners?
Yes, thank you, Kathy. As I think is known to everyone, the whole status of short-term rentals in Nantucket at the present time is governed by the decision that was recently made in the land court by Judge Vey in one of several cases that had been brought, and this was the first one that that came to a head for hearing, in which the judge made the determination that short-term rental is not a permitted use in the residential districts of Nantucket. Specifically, this was a case involving the old historic district, and the decision that was made states that the the short-term rental use is not permitted in the ROH, residential old historic district, but the same definitions apply, and the result is that that applies in all districts. And specifically, there were two aspects to the case. One was an appeal that was filed by a neighbor to a decision of the Board of Appeals that upheld the determination of the building commissioner that short-term rental did not constitute a violation of the zoning bylaw in the case of a short-term rental for residential purposes and in a residential district. The plaintiff in that case, the party who was appealing, also requested the court to specifically determine, as a matter of declaratory judgment, that the not only that in the particular case the bylaw had been violated, but that specifically the the short-term rental use was not legal, and that was an action against the town specifically rather than against the owner of the property that was the subject of the initial part of the suit. So the result is that when the court made that determination, that became binding against the town when the town determined not to appeal. If the town had appealed that to the appeals court, then there would have been a further determination made by the appeals court, and it would have been ruled on at that time. However, the town decided, for whatever reason, not to appeal, and the result is that that decision is final and effective as far as the town is concerned. It's a final judgment. What is still open in the case is the question of whether the specifics in that particular matter involving the extent of the use by the owners of the property for their own purposes, family purposes, and for short-term rental purposes, whether under those circumstances the the short-term rental use would be determined to be a ancillary use, accessory to the primary use as a single-family residence. And the case has been remanded by the land court, not on the overall issue, but on the sole issue as to whether under the specific facts of that case, the use by the property owners as short-term rental constituted an accessory use that would be permitted. And that matter will be coming back before the Board of Appeals. After it goes to the Board of Appeals, it can then be anticipated that whichever way it turns out, it may well be acted upon further by Judge Vey after remand, who will either uphold the determination of the Board of Appeals or overturn it if he considers that it was not based upon valid legal grounds. Obviously, the result of this is that, first of all, there's no question that unless action is taken, in general, short-term rentals in Nantucket are no longer permitted in residential districts as a result of this decision, unless they constitute an accessory use. And there is, in fact, no definition in the law or in any case that will specifically determine what the ground rules are, what constitutes an accessory use, what set of facts, and it's very fact sensitive and fact driven, will cause the particular property to be considered to be an accessory use. The facts are always different in every case, and the result is that it is open in every case for litigation until such time as some action is taken to establish definitive guidelines under which the question of accessory use can be determined. All of which means that unless some action is taken, we have a grave degree of uncertainty. Leases that have been signed for the 2024 season are in doubt as to their validity and whether the occupancy by short-term rental tenants will in each instance constitute a violation of the zoning bylaw. And action, therefore, needs to be taken to clear this up. Furthermore, if it isn't, there will be a potential for a great amount of continuing litigation regarding the whole issue, because, as I say, each case depends upon the facts, and the facts and the final analysis on this can only be determined by a court of competent jurisdiction. Therefore, we wind up with a situation where that decision being in place, it is, I think, imperative that town meeting, take some action in order to clear this all up. And that will lead into Stephen's explanation of the presently pending warrant articles.
Thank you, Arthur. And thank you. I'd like to thank Nantucket Together for organizing this. I see there's 84 participants. I think that's great. And I assume that some are for Article 59 and 60 and some are against, and some just want to learn a little more. So that's great. I do want to clarify, although I'm an attorney, I am not a member of Nantucket Together or an attorney for Nantucket Together or an attorney for anyone paying me or otherwise hiring me to sponsor Article 59 and 60. I am just acting as a citizen in doing that, although I do not own a short-term rental. I think that, we were really lucky that Article 59 was put in place because it was originally put in place as a placeholder with the idea that we didn't need it because it actually represents the exact law as it was understood by the town before the judge's decision was issued and how the town has acted in every situation since then. The building commissioner has issued 4 decisions that are consistent with Article 59. The zoning board has issued 4 decisions that are consistent with Article 59, and the town has adopted a registration system and taxation system and other articles that suggest that Article 59 is the short-term rentals were legal in the way that Article 59 does them. So Article 59 was intended to just be a way to make sure that if the legal decision came out and it needed some help, that we would be there. And fortuitously it was. There are Article 59 only does 2 things. It's very short, it's very simple. And there are 2 main points in Judge Vay's legal decision, the Land Court decision, and those 2 main points are addressed in Article 59. One of the major arguments in the legal case was that short-term rentals are a commercial use and therefore are not allowed in residential zoning districts. And the judge dismissed that as entirely the wrong question and not correct. So I think we can set that aside. However, there is a change there's a clarification. One of the things that Article 59 does is clarify the definition of commercial, which currently has a number of exclusions to it. And one of those exclusions is residential uses, private residential uses, and the change would add rentals thereof. To it to clarify that rentals of private homes are not commercial uses. Although that language is going to stay, it's not actually needed in the sense that the judge did not determine that short-term rentals are commercial use and therefore not allowed. But I think that clarification is still important. The second thing that the judge said is not that short-term rentals are illegal or illegal on Nantucket. What he said was that they're not expressly allowed as a use under the zoning code. The Nantucket zoning code just doesn't address them. The short-term rentals and any kind of rentals are not really addressed as a use under the zoning code. And the reason is, Nantucket has for 50 years since zoning was put in place and for 100 years before that had a thriving tourism industry that was mostly based as putting people up in private homes. And we have voted literally over and over and over to have very few hotels here, to have no resorts here, and to have people stay in private homes. That has been put in place and reinforced by our zoning code since it was adopted in 72 and all of the town's policies and actions since, which is why luckily we do not have large hotels or many large hotels and resorts here. There's less than 1,000 hotel rooms on Nantucket. And it should stay that way. We don't want 40,000 people here staying in high-rise resort hotels. All right, I don't. And I don't think many people do. So the other thing that Article 59 does is very simply create a use in the zoning code for short-term and long-term rentals, and then say that those are allowed in any zoning district except for the commercial industrial district, which is essentially the state of the nation before the judge's case. And it would allow for all of the short-term rentals that are currently in place and for future short-term rentals to be more clearly legal under the zoning code. Why do we need that? A lot of reasons. One is that, as Arthur said, essentially every lease for this summer is questionably legally valid, and any lease that is entered into for the summer or for later is questionably legally valid, whether that's for use of a primary dwelling or a primary use or an accessory use. There is no definition of what an accessory use is. There are some people who would tell you what they think it is, and I have an opinion, and Arthur has an opinion, and everybody has an opinion, but none of us, nobody on this, I think, is a judge in a case that could make that decision. So there is no conceivable way at all that there could be any legal determination that would make all of those leases legal. The zoning board is going to hear that case in June, but whatever decision they issue, whether it's broadly defined or narrowly defined, is likely going to be appealed. So that determination is likely going to take years to work out in the legal system, unless Nantucket, essentially puts on its big boy pants and makes a decision and adopts a zoning code that doesn't need any further interpretation. And I think that's exactly what we should do on May 7th, is put in the zoning code a definition for short-term rentals, so that we would stop having all this we don't have a decision made by a judge in Boston. We don't have a decision made by a local zoning board, and we don't have a decision that goes unanswered for months or years. We can make that decision ourselves. Then the question is, well, if we do that, are we then stuck with it? Because one thing that's not in Article 59 is a bunch of rules. We have had many zoning code, many warrant articles that have had both an adoption of short-term rentals, but also a bunch of rules that go with them. And this one doesn't have that. It's a very simple, clean article. And the answer is, we don't need any of those. And in fact, it's better for the people that are concerned about short-term rentals that they're not in there. And the reason is that changing the zoning code takes a 2/3 vote at town meeting, and changing a general bylaw only takes a 50% majority at town meeting. Usually, you would end up with what's called grandfathering or pre-existing non-conforming status for zoning under when you adopt something under the zoning code. However, there's a special state statute that was put in place a few years ago that allows for the collection of the short-term rental tax, that also says that towns can regulate short-term rentals through their general bylaw. That means that once you adopt zoning, short-term rentals into your zoning, you can then put all of your regulations, any regulation you want, in essentially that's legal, into the bylaw with only a majority vote, and that is how we should regulate it. And the reason why I know that's true is we've already done it. We've already created bylaw 123, which is the short-term rental registration system that the Board of Health has spent the past 2 years putting into place, that has a number of health and safety rules and requirements and nuisance mitigation and other things like that. And in fact, there's a warrant article that would do just that, Article 60. Article 60 would prohibit issuance of certificates of registration for short-term rentals in essentially 3 circumstances: corporations, affordable housing, and timeshares. And I think there's a general agreement for people that are on one side or the other of the short-term rental debate that nobody really wants large corporations coming in here and buying up houses and using them like hotels. And that would not be allowed if Article 60 is passed, which is why I would encourage people to pass both Article 59 and Article 60. Passing Article 60 does not solve every problem with short-term rentals that might exist, nor is it intended to, but it solves one of the ones that I think both sides agree on, and it helps demonstrate that we can regulate short-term rentals with only a 50% vote. So that's where we are. We're in a situation where essentially all short-term rentals are questionably legal, where there's only one way to make them legal for this summer. That warrant article is on as Article 59. And then for people who want to have regulations in place, they can do that regardless of zoning by adopting majority vote bylaw amendments, both at Article 60 for corporations and in the future. My understanding is that the select board is going to vote to adopt a fall town meeting, so that people will have certainty with the idea that they can vote to put those changes and regulations in place in the near future. I think that's a great idea. I think we should have whatever rules and regulations people think are a good idea to make sure that neighborhoods aren't bothered by short-term rentals, and for the most part, they're not. But if there's a concern, ultimately, the best way to control short-term rentals is to have rules that make it so that you can lose your certificate of registration if you're not a good neighbor. Year-round residents can be good or bad neighbors. Workforce housing can be good or bad neighbors. Short-term rentals can be good or bad neighbors. Long-term renters can be good or bad neighbors. Summer residents can be, who are long-term, who are owners, can be good or bad neighbors. The only ones who are going to have that regulation over their head that you might lose your ability to rent out your house are those short-term rentals under regulations that we have in place. And that is what I think is the best way to control neighborhoods and make sure that we have nice, quiet summer visitors who are just as respectful and enjoy Nantucket the same way we all do, as a activity and as a place to visit. And if the homeowner can't control their renters, they're going to lose their certificate of registration, and they should. That is the way to regulate rentals, not with crazy rules that require us to count how many nights we sleep in our house and report that to the town. I hear people say, oh, well, you can rent out your house as much as you want. You need to sleep there more than you rent it out. Well, I'm not really a fan of reporting to the town how many nights I sleep in my house, and who's there. And that's crazy. I'm really surprised that that's what some people want a system that's what we're going to start doing here. The other problem with the idea that we should just have ancillary uses is, people say, oh, let's go back to how it used to be where we just had ancillary uses for short-term rentals. Well, it sounds good, except for the fact that it's not true. We've never had a system where all the summer people stayed in year-round people's houses and their cottages, and it was all like some small towny thing, maybe in the 40s and 50s, but not in any modern scenario, certainly not since zoning was put in place. But there's a couple of problems with it. One is most summer visitors want to stay in nice summer vacation homes, not the houses of year-round people. And if they did, I don't know where the year-round people would go, because most of us are here in the summer working. And they don't want to stay in our cottages. They want to stay in, if people are lucky enough to have them, a garage apartment or a cottage. There aren't enough of them, and it's not where people want to stay. Most people want to stay, most of our summer visitors want to stay in the homes that are either just rentals or that are rentals but are owned by summer people that don't stay in them as often because they need to also rent them out to pay their mortgages or to make offset their expenses or whatever. And we would have to have 2,000 Nantucket families move out of their houses in the summer to make room for all of the summer visitors we have. It's the wrong houses and the wrong math. It doesn't work. It's nonsense to suggest that, oh, we'll just go back to ancillary housing, ancillary uses, and that'll be fine. That'll be nice and quiet. It won't. And frankly, even if you did that, even if there were enough of it, even if it made any sense, it still doesn't push. In fact, that pushes all of the short-term rentals into neighborhoods where year-round people live, instead of letting them be out in the places where, frankly, almost nobody lives. And so that ancillary use pushes all of the short-term rentals to where people live all the time, or trying to. Except it drives up the cost of everything, because you're now hyper-concentrating the number of weeks you have to the best weeks in the summer that are the most expensive weeks where people can make the most money. And you've now killed your shoulder season because you don't have enough weeks for that. So all these people who come for weddings in the spring and hunting in the fall and the festivals that we have and the holidays and for stroll and Christmas and Thanksgiving, well, they can't do that anymore because those long weekends would be banned under the way the people who are against this are talking about it. They want to just have people rent their houses for 2 weeks and call it a day. It doesn't make any sense. Nobody wants to see Nantucket be a place where investors come and just make money and pillage the island. But that's not what's happening. It's a total myth. It's a lie. It's not a myth. It's an intentional lie. There's no group of people waiting to snap up houses that are all going to come in and take all the money off Nantucket. Most year-round, most people who do short-term rentals do it because it's the only way they can make it work for their own Nantucket dreams, whether it's to live here year-round, whether it's to have a summer house here. You know, the economics do not work for people to come in and buy up Nantucket houses and rent them out and make all this money. And the reason why I know that's true is that up until the court case in March, there were not dozens and dozens of people buying up Nantucket houses and doing that. There are very few of those kind of investments. And frankly, most of them predate the price surges that we've had. You know, pre-COVID, you could buy up a house for $1 million-ish. Today, you'd be lucky to get half a duplex for $1 million. You know, the kind of houses that people buy for short-term rentals cost $3 or $4 million now. And the economics of renting out a $4 million house are not that profitable. You know, we are just not in an area where off-islanders are taking money and scooping it up and sending it off-island. What we do have is a situation where short-term rentals are a way for mostly local people or summer people to offset their bills and to use that money to pay their property taxes, to pay their caretaker, to pay their lawnmower, to pay their irrigation company, to pay their house cleaner, and then to have people come here and spend that money locally at restaurants, at retail stores, at all kinds of shops and services, to hire people to perform, you know, all kinds of services for them. And eventually, all of those short-term, not all, but nearly all buyers start off as short-term renters. And so when you have people come as renters, those people then buy houses here, they renovate those houses here, they pay architects and lawyers and contractors to work on those houses, and then landscapers and caretakers and cleaners and like there isn't a Nantucketer whose income isn't affected by dollars that come either from short-term renters or from the places that the short-term renters spend their money. Short-term rental taxes now make up about 10% of Nantucket's annual budget, but you know, of $100 million, $10 million of that annually is now coming from short-term rental taxes. So if people decide we don't need that money, we'd have nobody shopping in our stores, nobody hiring service people, and massive holes in our town budget. And that's just the short-term rental tax budget. It doesn't count all the fees, all the people pay for buying permits and meal taxes and all other kinds of tax and revenue and fees that short-term renters generate. But we'd have this essentially a massive economic downturn if Article 59 is not adopted and tens of thousands of leases are validated, where those people have no place to stay and can't legally come here. There's going to be no one to shop here, no one to buy things here, no one to spend money here. It's an economic disaster. And for some people, unfortunately, that's the whole point. That's what they want. You know, people ask me, why are people against short-term rentals? And I say, don't look at me, look at what they say. If you look at Act Now, they put out a white paper. If you look at putting Nantucket neighborhoods first, they have had an op-ed piece. Both of those said the same thing. The problem with Nantucket, Nantucket's problem is all these summer people coming here and all the local people and all the additional people that are needed to service them. And that's their point. They want there to be less visitors and less people servicing them. In other words, the problem with Nantucket is the Nantucketers to them. They see us as a service class and too many of us here serving the people who can't afford to buy a house and need to rent it instead. That's what they see, and that's what they say. That's not my opinion. And you know, we ask them what the problems are. It's, oh, well, you got too many cars on the road, and they're taking up the parking spaces, and I can't get a restaurant reservation. And then we got to build a new hospital for them, and we got to expand the school for their kids. Oh yeah, we got to raise taxes and donate money so that we could support all this infrastructure, because too many summer visitors need too many workers, and if we just had less, that'd be great. So you want to know why people are against short-term rentals? It's because they want to have better parking and easier restaurant reservations and less of us around to get in their way. So unfortunately, that's their own words. I just think it's very, very sad.
Thanks, Steve. Can everybody hear me? I have to apologize that my video is frozen. That's just to prove that I actually am on Nantucket right now, and my Comcast got upgraded, quote unquote, this week. So I am here, and that's me in front of the house. And unfortunately, you can hear me, and that's good. So let's move on to some of the questions that we've gotten. I'm going to try and alternate between ones we've gotten ahead of time, and then the ones that have been posted in the Q&A, and then alternate also between ones that maybe Arthur would be answering or Steve would be answering. So one of the first questions I have up here, and I think I'll pass it along, is there's also, before I do that, there's a few questions that are really not for either of the panelists. They might be more for me based on how I introduce myself. So I'll save those for last, and we can answer them. I can answer them offline and not bother anybody else. So first question here is, I am new to all of this. What is the whole premise of limiting rentals in a town that has relied on tourism since the discovery of oil and town went into a 70-year depression?
So I think that's asking why is it that people want to limit STRs? I'll give you a couple of reasons. One is some people want less summer visitors here and less of us to service them, which I just talked about. I won't repeat myself. But they also suggest that somehow short-term rentals are taking money from the local, using a local resource and taking that money away, which is also not factually true. It's a myth. And then the other thing is this idea that it's commercializing or ruining neighborhoods by putting short-term rentals next to regular year-round housing. It's just not true, right? You could have someone who's a great neighbor who's a year-round tenant, a year-round resident, or workforce housing, or they could be terrible. And you could have someone who's a short-term renter. I mean, when short-term renters come, they live in the houses, they go to the beach, their kids play in the yard, you know, they have drinks with their friends, they do everything that regular people do. They're not causing more or less noise than everybody else. Summer people who own summer homes do the same things. People who live on Nantucket and are trying to work hard and have a little fun are doing the same thing. You know, if you live next to a house where there's a bunch of teenagers or whatever, you're going to hear it. If you live next to a house where there's, you know, a couple of dogs, you're going to hear it. You know, and by both of those, I mean my house, right? So, you know, there's no, I don't buy it that having a short-term rental next to you is any different than having a family living next to you. It could be, but that's why short-term regulation is a good way to prevent that. And if the landlord, if the owner doesn't, you know, control their tenants or pick the right tenants, then they're going to lose. They should lose their certificate. Whereas you can't do anything about someone who's a year-round or who's an owner who's a terrible neighbor. You know, try calling the police. They can't really do anything about it. Most things that are bad neighbors are not illegal. So I think that's what people are saying. They don't want disturbances in the neighborhood. They don't want all that money going off islands, and they don't want, and they would love it if there was less summer visitors and less Nantucketers to service them. I don't think any of those are good reasons to cause our island to have an economic catastrophic event, which is exactly what would happen if there were 10,000 illegal leases this summer.
Okay, next question is from someone who sent it in ahead of the webinar tonight. It says, isn't there a grandfathering, quote unquote, rental status that supersedes any restriction regardless of the outcome of 59 and 60?
Well, I'll take that. The answer is no, because this is not a question of the zoning bylaw having changed to restrict or prohibit short-term rentals. It's a matter of the court having determined that the bylaw, as it existed all along, did not allow for them, that the town was wrong in not enforcing the bylaw against short-term rentals, and that therefore it's not a pre-existing permitted use, and therefore no grandfathering applies to it. I suppose if someone has been doing a short-term rental on their property since before the zoning bylaw came into existence in 1972, that they would be grandfathered, but that would be the only exception.
Thank you.
The evidence involved would require going to the zoning board and proving your case.
Right.
Okay. Next question is from the Q&A. What regulations or restrictions do 59 or 60 put on a homeowner?
I'll take that. 59 has no regulations in it, and 60 only proposes 3 categories that could not have a certificate of registration: corporations, timeshares, and affordable housing. If people want additional regulations, they should write them down, propose them for next fall. And, I think the town meeting would be happy to vote up and down some good ideas or some bad ideas. But what we would, if 59 is adopted and there are no quote unquote guardrails on it, all we're doing is looking at the exact same situation that we've had for the past 50 years. It's not as if we're creating a situation that is suddenly different. 59 just puts in place the law as it was up until 6 weeks ago when Judge Vey's ruling came out.
Or as it was assumed to be.
Assumed to be, yeah, as it was thought to be by everybody else. And so when Judge Vey said your bylaw is too vague, go fix it, I think we should take him at his word and do that. But this summer and last summer would be the same, except that now we would have an opportunity for there to be regulations put in place with a clear standard, a relatively low standard of a majority vote at town meeting. And certificates of registration would also clean up a lot of things. There are already rules in place under the certificates of registration that didn't exist before. So for example, to get one, you have to make sure that you're passing all of your health and safety tests. You'd have an inspection, your septic system would have to be working. The number of people living there would be limited by the number of bedrooms you have. The parking would be limited. You'd have to have a phone number on file of a caretaker or an owner who could be available with a cell phone number. There are all kinds of rules that are already in existence under bylaw 123 that would come into place when the town turns on that system, which I think it just did this March, or it let people start applying for those. So those rules and bylaws are in place already, and there's plenty of ability to increase them or improve them.
Okay, here's one from submitted in advance. There are 4 STR articles on the warrant, but only 2 are being discussed. What about the others? What led to that situation? I think that would be Stephen would be the best.
Articles 60, 61, and 62 are all essentially the same. They all create some kind of corporate prohibition for short-term rental certificates. One was sponsored by me, one was sponsored by Michael Kopko, and one is sponsored by the town. And we had a compromise to put forward Article 60 that that takes sort of the best parts of each, and Article 61 and 62 are going to be set aside. But we could have any kind of circus at town meeting people want, but hopefully that's what happens.
Okay, a question from the Q&A. What do you do if your leases were signed prior to the Vey decision being handed down?
Well, we're talking about a circumstance in which short-term rentals have been determined to be illegal in residential districts. And subject to there being litigation in each individual case, there's nothing that gives any protection to the people, the landlord and tenant who have entered into the leases prior to this being in effect. Potentially, in each instance where there is a short-term rental, the town could come forward or could be required to come forward by a plaintiff or by the court and take action against that landlord for an illegal use of the property. And so therefore, the result is that it's an uncertain situation, and obviously nobody took it into consideration when starting to enter into leases for the upcoming season, but all of a sudden they're now potentially illegal.
Yeah. Actually, that's a good segue into the idea of one of the problems that Article 59 solves is that in addition to being a local decision on how we should do this, as opposed to having the judge make the decision, it would end all of those lawsuits. You wouldn't have litigation you wouldn't have to go to the zoning board. You wouldn't have litigation over the zoning board, and you wouldn't have neighbors suing neighbors. Act Now and its sponsors have spent $2.5 million trying to fight short-term rentals, mostly by suing local families who happen to rent out their houses but live next door to someone who is willing to act as a front for ACNAF lawsuits. And it's really been negatively impactful for the people who have had tens of thousands of dollars in legal fees because they happen to live next door to someone who didn't like the fact that there were some children laughing in the yard. I wish I was kidding.
Okay, thank you. This question is also from the Q&A. Can you please clarify whether any STRs will be exempt from regulations added in the future?
Absolutely not. All
No,
STRs would be covered by bylaw changes. The only STRs that would be pre-existing non-conform. All STRs that are existing would be became legal would be pre-existing non-conforming or grandfathered under zoning changes, which is exactly why all the regulations should not be in the zoning code under 50 and should be in the bylaw under 123, because there is no quote unquote grandfathering in bylaws, and therefore changes are impactful and effective on everyone that has a short-term rental certificate, regardless of whether or not they're legal under zoning. Those regulations would apply retroactively or effective upon adoption for everyone.
Okay, here's another question from the Q&A. Said, but if the existing bylaws had adequately addressed accessory use before the lawsuit was filed, the plaintiff would have lost, correct? Isn't that why drafting ancillary use provisions is the better answer?
Yeah, I think that somehow the question of ancillary use is going to have to be established. And the problem with relying upon court decisions to establish it is the fact that, as I said earlier, every case is different, and there's a broad range of potential results that could come out on what constitutes an ancillary use, depending upon each individual case. I think that going forward, it may be highly desirable to establish and codify what constitutes an ancillary use. But that's not in the present, in the articles that are before this town meeting. So that's an issue that needs to be determined later. We weren't, at the time that the warrant closed, certainly aware of exactly how the decision in the case determined by Judge Vey would come out, and therefore that wasn't specifically addressed. It can be handled to some extent through amendment to the general bylaw, which will be, as has been mentioned, able to be amended and evolve over a period of time through majority vote of town meeting rather than the 2/3 vote, which has been the problem with there being any kind of consensus being reached up to the present time when you're dealing solely with a zoning article.
Okay, thanks. I have another, I think there was some really good questions coming in on the Q&A, so I'm going to keep rolling with those. How can STRs be illegal if the state and town have been taxing them and regulating them?
So
two different sets of rules.
So I think it's important to understand that it has nothing to do with whether or not the lease was executed before or after the court decision, and nothing to do with this idea that STRs are legal or illegal. What the judge actually found was that short-term rentals are not expressly provided for in the Nantucket zoning code. So he said that the code is essentially too vague on this issue to find that they are an expressly allowed use. So he didn't say you can't have them, and he just said people haven't covered this. Figure it out. If you want STRs, put them in there. If you don't want STRs, don't put them in there. Or be, he didn't say STRs are illegal. He said that they're not expressly covered. So what we need to do now is go back to the zoning code and expressly cover them, and then regulate them as much as people think is appropriate to cover whatever issues there are. But until they are expressly allowed, they are all illegal. Because they're not in the zoning code. So it's not the activity itself that's the problem. It's the lack of it being listed in the zoning code that is the problem. But in the same way, you could have a zone that allows restaurants and whatever. Doesn't mean anybody can do a restaurant in that zone. You still have to pass health code. You still need your common vic license and your entertainment license and your liquor license. There's all kinds of other ways you regulate restaurants, even if they're allowed use. And so what Judge Bay has said is, if you want this use, put it in your code. And if you want to regulate it, go ahead. I'm not doing either of those. That's not my job. My job is only to say, is it expressly in here or not? And he determined that it's not. But he didn't say it can't be. He said, go back and figure it out. And that is what Article 59 attempts to do.
I'll throw this out there, not sure if you have numbers to answer this, but has there been a huge increase in the number of STR rentals on the island in the past few years?
I think they're
it's
actually
remained fairly
down.
stable.
Yeah.
It's maybe down to some extent. It has not been, from information that I've seen, been increasing in the last few years.
Yeah, I also think it's hard to tell because COVID has thrown off the numbers so significantly on the number of houses that people bought as second homes, and then the number of houses, and then when people weren't coming here at all, and then when they were. I think that statistic on recent activity is very difficult. But I can tell you from my law practice, and I think it's probably similar in Arthur's and island-wide, is most of the people we have buying homes here are either year-round residents who are very lucky to be able to afford a home, or businesses buying employee housing, or summer people buying homes that they hope to use some and rent some, or maybe they're just going to use it themselves. I can't think of anyone that I've represented who is buying a house only to rent it out. And I think that myth is very misleading and not true. I'm sure there are some, but it's not really economically feasible for people to buy a $3 or $4 million house and then rent it out with the expenses that we have here and the taxes on that income and everything. It's not if it was a winner, you would have seen those numbers going through the roof, and we just haven't. But we see a lot of people who want to rent here, who want to come for a week because they love it.
Thanks. What position will STR homeowners be in if Article 59 is not adopted and Article 60 is adopted?
Well, a great many illegal leases at that point will be subject to rules that are established under 60. I mean, 60 limiting corporate ownership and the like doesn't have a great deal of bearing on things if Article 59 doesn't pass, frankly.
If Article 60 passes, it means you won't see any more short-term rentals owned by large corporations. That's essentially, which is a very small percentage of STRs right now. I think the statistic is less than 4%. But if Article 59 doesn't pass, every single lease is questionably legal, and you will see less and less leases entered into for that reason. And you should see the town bring enforcement action against anybody who violates that, because they would be on legal notice of it. And what I'm sure you'll also see is Act Now and putting Nantucket Neighborhoods First, getting people to sue their neighbors and file zoning complaints against their neighbors, and have the town issue fines against their neighbors because they had a rental. And then people are going to have to come in and say, oh no, I should qualify for an ancillary use because here's my diary and I slept in my house 181 days last year and therefore I should be exempt. That sounds like the kind of Nantucket I want to live in for sure.
Okay, here's an interesting one. Can a homeowner or a tenant use the current ambiguity to get out of a lease?
Potentially, yes.
Yeah, unfortunately, that's a really dangerous legal question. But can you have a lease for something that is in violation of zoning? Highly suspect.
Yep.
Okay. let's see if I've got another one here. What do you think the odds are of 59 and 60 not passing? At the moment, there seems to be a 50-50 for and against. If they don't pass, what will the next steps be?
Well, I'm sure the people watching this are going to be highly persuaded to vote for 59, so I'm sure that'll do it.
Another question, why would we need to define ancillary use if we vote to allow STRs in all residential districts?
Well, that's a good question. Obviously, I think that rather than being a question of needing the zoning bylaw to be amended in that regard, maybe that further regulations, if we determine that they're appropriate under the general bylaw, would be able to address situations analogous to that. But it's a good point. We probably don't need a further amendment to the zoning bylaw, as I was suggesting earlier, if Article 59 passes.
Yeah, I think part of the problem that we've had with some of the regulations that have been proposed in the past is that there's solutions in search of problems. And when people, what I mean by that is people are like, oh, well, we should have this rule and that rule and this other rule. And I always ask, well, what problem are you trying to solve with that? Because does limiting the number of nights someone can rent their house actually solve a problem, or does it create a different problem? You know, and I am all for identifying problems and then coming up with ways to solve those problems. But a lot of the limitations that people have proposed would only wind up hurting local businesses, hurting local homeowners, raising prices, hyper concentrating rentals in local neighborhoods, hyper concentrating rentals in the high season instead of the shoulder season, and really have no beneficial effect. So I think we should definitely have a lot of regulation that addresses problems, but we should figure out what the problems are before we figure out what the rules are.
Okay, another question that was submitted in advance. Do STRs cause a significant decrease in the amount of affordable housing on the island?
I think the answer to that is no. In general, we're dealing with a different type of property. Stephen was alluding to earlier in terms of the types of properties that are used for each of these uses. The types of houses that are used for short-term rentals are typically the types of houses that summer residents would live in rather than year-round working people. And the areas of the island in which short-term rentals are taking place are primarily, shall we say, the more upper-end areas rather than the areas where the great concentration of affordable housing is located.
Yeah.
At one time, you certainly would have had a mix in town of year-round people living in the downtown area, in areas where there are a lot of short-term rentals, and year-round people have largely moved out of downtown. The concentration of the year-round population is mid-island and surrounding areas.
Yeah.
So we're dealing with two different markets, two different price points, two different areas. There's not a correlation between the two.
I think that 5 or 6 years ago, there might have been some more affordable, you know, not really affordable, but more accessible units that were, you know, the year-round people could have bought that may have turned into rentals. You know, frankly, there are $5-6 million houses on Parker Road and Hooper Farm Road now, which would have been inconceivable 10 years ago. But those aren't short-term rentals. Those are, you know, houses that people have bought and made, you know, built really fancy houses on and whatever. I think we essentially have two markets. One where summer people compete against each other. And if you take the short-term renter out of that equation for these, you know, $3 million and up houses, you haven't helped the local person or the affordable housing. You've only helped the person who needs the least financing and can offer the highest cash, no condition deal. You're helping, summer buyers beat out other summer buyers. Now, who are local people and affordable housing people competing against? They're competing against local businesses buying workforce housing, not short-term rentals. And that, we have a number of real significant housing issues on Nantucket. It's a crisis, and it has been since the 80s, and it's going to continue to be for a while, and we definitely need to do it. But, cutting short-term rentals out of it is like saying, I'm going to fix my broken window by burning down my house. It makes no sense whatsoever. It doesn't help affordable housing at all. There's lots of things we can do for affordable housing, but none of them are related to short-term rentals, and certainly not the way the market is structured today. Essentially, Nantucket made the decision 50 years ago that we wanted people to stay in houses instead of hotels and resorts. And because it's so nice here, more and more wealthy people come here, and we buy up land for conservation, and we have, very little development here relative to the size of the island. And it's very, very nice to come here. And that just gets more and more expensive every year. And unfortunately, we are the victim of our own success here in a lot of ways, but none of it has to do with short-term rentals. And all of it has to do with how nice it is to come here.
I would point out that about 10% of the town's budget is now derived from the occupancy tax, the great majority of the occupancy tax on short-term rentals and hotel and motels comes from short-term rentals. I had actually made a proposal to have a large amount of that be dedicated by the town for affordable housing, which was before town meeting on a couple of recent town meetings, and it was finally determined by the town in response to that they would not do it specifically by earmarking funds from the occupancy tax for affordable housing, but instead to put through a provision by which there will be an ongoing funding for affordable housing of a somewhat similar amount to what I had proposed. And in any event, if that source of funding is not available, has an effect upon everybody else's tax rate too.
Okay, we're about at the end of our time. I know that Steve Cohen is willing to stay on and answer more questions if we'd like to do that. But before we decide if we want to go forward and do that, I just wanted to ask Steve and Arthur, is there any other piece of information, a question that has not been asked that you think people should know? And if so, please share that quickly.
I think that people who want to know why short-term rentals are on the hot seat should think about just how politics works in this country. Unfortunately, it's easy to point at whoever you want to be the enemy and say, all my problems come from that person. And whether that's, immigration or like Brexit or any of these things that get people whipped up into hysteria, they don't solve any problems, right? That's not because they didn't cause the problems in the first place. If short-term rentals are 100% legal and entirely unregulated, it would have no negative impact on Nantucket. But if short-term rentals are banned, our economy would crater. The town would have a major hole in its budget, and we would have massive problems. There are no problems that would be solved by banning short-term rentals. There are some short-term rentals that should be reined in through regulation, which we should put in place. But I just can't conceive of what problem it is we're solving by banning short-term rentals, unless you think the problem is we should have 20 or 30 or 40,000 less people here. That's the problem they're trying to solve. So do the math on what that looks like.
Arthur, anything for you?
Yeah, I'm looking at some of the questions and answers that are posted by some of the attendees, and there are a few things in there that I think I'd like to address. One question that's raised is what is the definition of a large corporation? We're actually not talking about large corporation. We're talking about corporation, period, versus a realty trust or an LLC. A corporation is something that is filed in the corporations division of the Massachusetts Secretary of State or similar place in other states as a corporation. The restrictions in Article 60 would apply to all corporations, whereas a realty trust is not covered. An LLC is referenced in some of the proposals that I've seen, but an LLC is not covered by Article 60, and LLCs are very frequently used to hold title to Nantucket real estate these days for reasons relating to having nothing to do with short-term rentals. We certainly do always advise clients who rent their houses at all to put them in LLCs for liability protection purposes, but properties are put into LLCs by many people for other reasons related to estate planning and taxation, and those are separate from the concern with corporations per se coming in and dealing with it. And there was another question that was similar to that that was raised, but I think my answer covers. Someone says, regardless of ATM outcome, is there anything the ZBA can do to expressly allow short-term rentals? No, they're operating within the law, and they were appealed from in the case decided by Judge Vey, and they're bound by that case. They will be coming back before the ZBA as to the specifics of that case, but the only thing the ZBA can do at the present time is to adjudicate and determine what actually constitutes an ancillary use in each individual case on those facts.
Okay, well, I gotta tell you what we're gonna do. First, thank you so much for all of the questions, and thank you for the panelists for preparing and coming and speaking with us tonight. A very special thank you to you both. What I think we'll do is, we do have a lot more questions, though we're going to capture all of them. I think we can get them answered offline. We can get written answers to the ones that haven't been answered live, and we can post those FAQs as I mentioned earlier. So just so you know, everybody, we will post a link to the recorded webinar from tonight, and once available, we'll provide a link to it on our YouTube account, which is at Nantucket Together. We'll put it on our website, which is nantuckettogether.org, out in social media, the Daybreak and current Nantucket Current e-newsletters. Again, thank you.
Kathy, I do want to say one thing. I want to thank Nantucket Together again, but I do want to say that Arthur and I are both attorneys, but nobody listening to this should consider this legal advice or an attorney-client relationship. If you have a question about it, whether a lease is legal or something like that, you should be consulting your own attorney and getting advice on your specific situation. Don't rely on this webinar as legal advice. It is not. But you definitely should show up at town meeting on May 7th at 5 p.m. at Nantucket High School and vote to make your voice heard. Thank you.
Yes, thank you very much, everybody. And we will see you at town meeting. Please attend and please vote.